other ad hoc committees. Good morning. So the first rule that is proposed for the committee today was 20P21 VOSHA Review Board Board Rules of Procedure. The witnesses before us today are Lee Kaiser, Lee Kaiser Phillips of the VOSHA Review Board, Carolyn Desch, Clerk of the VOSHA Review Board, and Dirk Anderson, General Counsel of the Department of Labor. And the floor is yours, and we await your testimony on the rules before the committee.
Thank you, Senators. We're glad to be here today. I am Lee Phillips. I am Chair of the VOSHA Review Board and have been so for almost 25 years. Carolyn Desch is our clerk and also is a certified paralegal. And I will allow Dirk to introduce himself.
I'm Dirk Anderson. I'm General Counsel to the Department of Labor. And as a resident of the town of Orange, you are my senator, Senator Benning, and you were my senator, Senator McDonald. And I guess I'll just turn it back over to Lee, but just want to state that the VOSHA Review Board, the VOSHA Department, the Division of Occupational Safety and Health resides in the Department of Labor. The VOSHA Review Board is an independent review board appointed by the governor. So when there's a contested VOSHA citation, the review board is where that citation is heard. So in a sense, we're not the same, but we're partners.
Yeah. And I felt it would make more sense for the three of us to be up here in case we have more of if we were discussing something to, instead of bouncing up and down, you would be here to discuss it. You have a lot of materials that have been provided to you. There's a summary of changes, their comments and responses. I will tell you that when I first was appointed to the board in the mid-90s, the current rules were adopted then. So it has been a long time, and it is very much time to update these rules. Back then, it was the Commissioner of Labor and Industry, and now it's the Commissioner of Labor. Times have changed. In addition, the federal equivalent of the review board, some states have a federal VOSHA program, and therefore they have a federal board, the commission that reviews any appeals of citations. They have just redone their rules. And so we have used those rules basically as our template to be in sync with them. That will allow interpretation of the rules in federal cases for us to rely on those and interpreting them down the road. I'm not going to read through the changes and the materials that you have. Suffice to say that this has been a multi-year project. I want to give kudos to Carolyn Desch. She has spent an enormous amount of time putting this all together and working with the board, working with our hearing officers, also conversations with the Department of Labor as well as other interested parties out there. And we feel that this has brought us into the 21st century, so to speak, and it has expanded in certain areas. We're now allowing discovery, which a lot of attorneys as well as the Department of Labor had wanted in certain cases. We have found over the years that we're seeing fewer pro se people and more attorneys. So our rules really do have to be updated and in line for purposes of working with the attorneys and with the board. I guess I'm really going to open it for Oh, I guess I was supposed to mention, we did make, there were 3 changes that LCAR's review came up with, one of which does need to be dealt with in a motion, which I believe was Anthea presented to you all in an email. And it relates to a, where's that email? The email's missing too.
Oh, no.
Yeah. Where did that disappear? I had all this stuff. So it relates to,
Statutory change.
there was a statutory change and it's rule 2200.1L. It should read subsections 225A and 226B as opposed to 226A and B. The statute made a change, and so there had to be a shift there. There were also 3 or 4 typos, but those don't need a motion to change.
In any event, there'll be, we're not taking any
Right.
motions today.
Right.
But, and we have copies of
Okay.
what you were referring to, which will come up at the meeting
Yeah.
2 weeks
So,
down the road. And thank you for
Yeah.
ferreting out those troublesome Scrivener's errors that show up when rewriting lengthy text.
Damien found those, but
yeah, Damien, yeah,
thanks to him.
yes. Does the committee have any questions? I mean, I know you don't want us to go through it section by section, but
Senator Benning.
First, let me thank you for the summary of changes. Very helpful. I did note that you have a change that permits one side to ask for an expedited process. And I was curious, is there a mechanism if one side requests it and the other side does not want it, how that is resolved?
I believe that would be up to the, in other words, one side would make a motion for the expedited process.
Mhm.
And they would have to make a case for it. And it would be up to the hearing officer to decide based on the facts and circumstances presented. So it would be on a case by case basis.
But the hearing officer would have the veto power over that question.
If it was not, in his or her opinion, not appropriate or necessary.
Okay.
And we do have a section that allows us to use the civil rules of procedure to follow anything that's not presented in these rules. So the hearing officer can use can go there for any help needed for guidance.
Thank you. That was my question.
Might you direct us to the section which authorizes the hearing officer to make that decision on his or her own opinion? So when we take this up in 2 weeks,
Yeah.
we have the same view of it that
Yeah.
you've just shared. So
Senator Benning, do you remember where you picked that up?
Initially, I know I saw it in your
Hearings. Let's see.
cover sheet.
yeah,
Is this
Cover sheet.
interlocutory review
Oh, interlocutory review,
and interlocutory?
yes,
Or your-
that would be page 37. Well, interlocutory review is a different issue.
Okay.
Interlocutory review is if the hearing officer makes a ruling on a particular issue within the case, not a final decision on a case. Interlocutory means that that decision is appealed before the final decision. So that's a different, totally different issue.
Okay,
And that was allowed under the prior rules or the existing rules now, but it hasn't changed. However, that, I don't ever remember that happening in the last 25 years. It's a rare circumstance when that would happen. but again, it's at the discretion, it's actually usually at the discretion of most judges, I believe, in the judiciary system.
Oh, I see, it's on page 48.
48. Expedited, so it's rule
103.
103. So it says the review board may order. So again, it's a discretionary thing. Automatic expedition would be when employee contest or petitions for the modification of an abatement period. What the abatement period is when an employer has been cited, and Dirk, you can correct me if, okay, when an employer has been cited for a violation, they are also given a period of time in which to correct it. And obviously some violations can be easy to fix. Others can take more time and effort. So there can be for instance, employees can petition to have the abatement period maybe reduced because they feel they're in an unsafe situation. So something like that would be expedited, because if you delay that, you're sort of, if they want it shortened and you delay the hearing, it sort of makes the issue of shortening it moot. So do you have any other comments or thoughts on that?
Do not.
Okay. Does that answer?
Helps to clarify, and there may be more questions.
Yeah, okay.
Senator Ray.
Thank you. So I have a question that's broader than the rules before us, and that is COVID has been a whole new experience for us. And so there were lots of discussions in the last 16 months about what's a safe workplace and whether and so can you just comment on how these rules, what role they play in establishing a safe workplace for workers who may or may not feel safe in that situation? The employer may or may not be required to provide certain spacing, which may or may not be possible because of the physical setup of an assembly line or something like that.
The rules and regulations with respect to COVID or any other safety issues are established under the OSHA regulations. We, as a board, can't deal with that. We are more involved in the enforcement. In other words, if an employee could call the OSHA division in the Department of Labor and say, I feel there's an unsafe situation here, and the division would send an inspector out, or they have regularly, or not regularly, but they will do inspections of certain work sites. Or you could be walking by a work site and see something you feel is unsafe and call it in, and they will inspect. And it's based on an inspection and finding a violation. So we are not involved in setting up those regulations. We are involved with an employer is cited, they appeal it basically to us, and based on the facts, we determine whether the citation was appropriate or not. And we can also look at the penalties, but those are established through we actually brought the form, a very specific formula based on, how serious the injury could be, if if the safety regulation wasn't followed, and the probability. So we work within those, so we can't arbitrarily say, oh, we don't think it should be $10,000, we think it should be $5,000. It's based on very specific formulas. But your question about COVID is very interesting. I expected more COVID cases to show up nationally. That's starting to happen. And I know there are, regulations, and I think that's going to start popping up down the road, but we don't create those.
Right.
That's more the Department of Labor's bailiwick in terms of inspecting, and the regulations are established by OSHA federal regulations.
Okay.
And Senator, if you'd like, I can follow up on that on behalf of the department. Again, these are rules of procedure on appeal. I'll try not to make this too long-winded, but at the beginning of the pandemic, federal OSHA came out with some COVID safety guidelines. They were not rules or standards, they were guidance. And the Vermont Department of Labor took the position of essentially being a advisory. VOSHA was an advisory capacity. If we got complaints, VOSHA got complaints about unsafe workplaces in terms of COVID protocols. We would issue a letter of inquiry to that employer. We would ask them to explain what they were doing to protect their employees. And we would follow up with them, ask them to submit to us evidence, pictures, manuals, whatever, of what they were doing to protect the workplace. But there was no actual COVID standard. About a month ago, federal OSHA did, through federal rulemaking, adopt an emergency COVID standard, just in time for the end of the pandemic, essentially, but they did do that. And as a state plan state, we have an obligation, we, the Department of Labor, to adopt that standard as well, a standard that's at least as protective as the federal standard. And I believe Charlene, that didn't Dan file the emergency rule with you a day or two ago?
Mm-hmm.
So you will be seeing an emergency rule very soon, adopting the federal emergency rule. So we will do that through emergency rulemaking. And then if we need to, if we feel there's a need going forward beyond the 180-day period, we will go through the regular rulemaking process. But prior to adopting an emergency COVID standard, all the department could really do was enforce COVID under what's called the general duty clause, which is all employers have the obligation to maintain a workplace free of known hazards. And for the most part, Vermont employers have been compliant. I think we've had, I'd have to check to see if we issued any actual general duty clause citations for failure to comply with COVID guidance. But going forward, once we adopt this emergency rule, we'll actually be able to cite to a standard. Is that helpful?
Well, yeah, so I think, since employees are in a somewhat precarious position in terms of their comfort with complaining, I did speak to people who were working in places where they felt like those conditions were unsafe, unmasked or not as sufficient cleaning protocol, et cetera. Things like that, especially early on as we're all figuring these things out on the fly. And so I know that your process is downstream of that. If a formal complaint's filed, and then I guess you're adjudicating that. But I was just trying to check in and see if we're in a better situation. Should there be another flare up or a new version shows up or whatever, so that we're all better off moving forward.
Well, to respond to that, and employees may not be aware of this, but if I'm an employee and I call the VOSHA division and complain about a safety issue, the employer cannot retaliate against me. That would be a legal violation too. So, people you talk to may not have been aware of that, but calling in a safety tends to trump a lot of things. And calling in and making a complaint, if the employer fires them or cuts their pay or does something retaliatory, the employer could be liable for that. So,
And our department does have a full-time whistleblower investigator to investigate retaliation. We do that on an ongoing basis. And under the VOSHA statute, there is a concurrent right to private civil action, as well as a complaint to the commissioner. And we do routinely follow up on complaints of retaliation and investigate them.
Okay, well, thank you. I don't want to go too far afield from our business, but I just wasn't sure about the relationship between what we're looking at today and the kinds of real world things that we were hearing about in the last
yeah, well,
15 months.
these rules would be applicable in a case whether it was COVID or non-COVID. It's, you know, for all citations which come before us.
Great, thank you.
Other questions? My question was the same that Senator Benning asked, which is if one party wishes to expedite things and the other party says, no, I want to go through this in detail. It's up to the my understanding is up to the hearing officer to make a decision. And the party who didn't wish to have expedited their, that party's recourse is to go to an alternative civil hearing?
No.
Well, what's the alternative of the party who's ruled, we're going to speed things up and we're not obliged to follow the timeline set forth in the rules and other things? What happens to that party in this, under these rules, which
Well,
have to be followed unless there's a
okay.
ruling that they don't have to be followed?
Yeah, okay, yeah. Well, yeah, there's automatic, and like the modification of abatement, because if you're trying to reduce the abatement period to get the safety measure sooner, obviously time is of the essence, and if you don't shorten it. Well, in theory, if it was another issue, I guess there could be an interlocutory appeal, but that would not be in civil court. That would be from the hearing officer to the full review board. And, but I think the other party would probably have to go along with it. The only way of something, a hearing officer would approve an expedited process is if there was a real issue with timing. You know, that doing something at a certain time was going to make a difference, or there could be, if you look at it like a injunctive relief, there will be irreparable harm or some serious consequence if we don't do this on a faster timeline. So I don't see it as a very regular option that will be pursued. Perhaps the state would have times when they might, the department might have times, but in all rules, there are times where if you lose, you've just got to go along with what the court has said. Now, there can be an appeal after a final decision too. They can appeal to the full board. It's a discretionary review. The board can review a hearing officer's decision and say, we want to review this. We don't necessarily agree with the decision. So there are two options for discretionary review. And then upon the discretionary review decision, if a party wants to appeal it, it then goes to Superior Court. And from Superior Court, it can actually go up to the Supreme Court, and that has happened. So does that answer your question? Yeah. Part of this is we've never had it before us, so it's hard to say what, you know, a fact pattern that would come up. I mean, I don't know if you could think of something where the state felt there was a need to have an expedited hearing because of a certain safety issue.
I can't recall us requesting an expedited hearing.
Yeah. So
It's good to have that in our toolbox as an option. You know, but it hasn't happened yet.
yeah.
Is that something that just popped up in Vermont, or is that OSHA that you're reflecting now?
We're reflecting.
Okay.
OSHA. And another thing that was added in here, which again, to try to resolve issues is parties can agree to go to sort of mediation with one of the hearing officers. This is something we did have it. We did have it before, yeah, expedited. Yeah. So instead of being a hearing officer to decide on the issues, they work with the parties to mediate. And if it doesn't work out, then another hearing officer would handle the hearing on the citation, the matter in full. But it's a way to try to resolve things a little faster and with less procedure and formality.
Is eligibility for that process based upon the size of the penalty that's proposed?
I think you're right, there are some.
There are none.
There are none for that. No, there are for simplified.
Simplified proceeding.
That's a different situation.
Right, but that just flagged in
Yeah,
my mind a
yeah.
question whether that you had to have a ticket entry point somewhere along the way, and that,
Yeah.
but that's not the same.
For simplified procedure, you do have to meet certain criteria. And simplified procedures used a lot, or it has been in the past, and obviously when you have a pro se situation, when the person is not being represented by counsel, that's the way they go. I will tell you, over the last 25 years, it's gone from almost everybody being pro se to now pretty much everybody, the employers are represented by counsel. We have very few pro se individuals. I don't know if it's because bigger companies are coming in. I do think part of it is because the penalties are much higher now. The federal OSHA raised the penalties significantly a couple of years ago. And for companies in Vermont, it's very significant. So there's more incentive to contest and fight the citation, because you're looking at $10, $20, $30, $40, $50,000.
Mm-hmm.
So, which is hard for the smaller Vermont businesses.
Right.
So I don't know if you have any comments or thoughts about the change over the last.
No, I agree. I think the increase in the amount of employers who are represented is probably a direct result of the increase in the penalty structure. It is significant, and there are built into the penalty matrix are reductions for smaller businesses, but if you're not a small business and we assess you a serious citation, it can be tens of thousands of dollars. And that's probably why they've gotten lawyers.
And if you have a repeat penalty, in other words, you've had a violation, and then within a certain amount of time, you do it again, you start having multiples of 5, of 7. So if your penalty was going to be $5,000, it could be $25,000 or $35,000. So you can see how things can ratchet up quite quickly.
So if memory serves, the simplified process is available automatically for anyone with a penalty less than 20,000.
Yeah.
Is still available between 20 and 30,000 upon the board's approval.
Yes.
Is that the standard? The increase in people represented, who came up with those numbers? Let's ask it that way.
That was the OSHA.
That's OSHA.
OSHA, their the review commission.
But if people are coming in with lawyers now more often, it sounds like the fines, the penalties are higher than those figures, which is resulting in legal process. I'm a lawyer, so I don't care. It's employment. But I guess I was curious as to who came up with the numbers and whether they are actually relevant enough in Vermont, given what is going on for penalties these days. And if you felt that that was something that needed to change in order to enable more people to come into that simplified process. What would trigger your desire to do that?
Well, I think if between the 20 and 30, I think if the parties wanted to do simplified, I think the hearing officers would agree to that. It's not an unreasonable request to do. I mean, you still sort of have rules, you just don't have the formal pleadings. You know, like you don't have to file a complaint, the citation is the complaint. You don't have to file an answer, your notice of contest is the answer. So it just sort of simplifies the pleadings process.
And with regards to documents that are submitted,
Yeah.
everybody's supposed to be exchanging documents freely instead of going through a more detailed
Yeah.
discovery process.
But in terms of the numbers, I don't know how you decide, should it be 50,000, 75,000? A lot of times the complication of the, you know, in the past, I've been asked when testifying on our budget, well, if you get a certain type of case, is it less expensive for you to handle? And it doesn't matter whether it's a fall case, fall protection, or ditch digging. It's the fact situation, and things can get very complicated in one fall protection case, but not as complicated in another. And so I don't know how we could really come up with a number other than what they have already that makes sense. Over time, yeah, maybe they need to be raised, but now we're seeing most are over 30, aren't they? They've been pretty high lately. So a few are under, but in terms of what comes to us, there are a lot of cases that do not come to us. They're settled at the within the division and are not appealed to us. So.
And another argument is simply that when, if you were to make those simplified proceedings too high for somebody, putting a lower limit on it is, from my viewpoint, is good because you want them to have more tools. As it gets more complicated, we want them to have the option to go into conventional proceedings, and they have the option to go into conventional proceedings regardless. There's no requirement that they go into simplified proceedings.
Right.
Yeah, if you're in conventional, you can do discovery, you can do you know, there are other things you can do, whereas simplified proceedings is much, you can't use a lot of those, as Carolyn says, tools. And
Okay. All right, so Senator Benning's question was the same question I had. If one party wants to expedite and the other doesn't, the rest of the stuff is sort of cast aside, and that it's, I don't want to say seat of the pants or fly by night. It's special to this case. You don't have to deal with all the rest of it. And when we talk about the parties, if we were having a discussion 25 or 30 years ago, the parties would be likely to be individual business owned by individuals. If there's been a change in our culture and our business climate, it's more likely to be a franchise owner out of state that has 40 enterprises.
no, it's
Who's going to
it's still local businesses. They just might be bigger local businesses.
see what?
Larger local businesses.
No, I'm talking about franchisees, whether it's fast food or clothing or the national franchises that you never had here 40 years ago, except for maybe a few. And I'm talking about a policy, and these are rules, so I'm already on shaky ground discussing this, but what's good for a small business to settle it And to, if an individual family is one thing, but for a national chain that goes, my goodness, if you settle it this way in this one, it's going to affect our other 49 stores in the state of Vermont. We don't want anything expedited. We want to go to the wall on it.
Again, there would have to be a fact situation where time was of the essence. You can't just, either the Department of Labor or the employer couldn't just say, I just want to expedite it to get it over with. There has to be a legitimate reason where something, probably it's a safety issue, such as if we don't fix this, it's probably closer to abatement. It's, again, as I said, I don't think it would be granted except in a situation where time was an issue, not just, oh, it's more convenient. It's not a convenience thing. Is somebody going to be irreparably harmed or injured or whatever? So it's in an abatement situation, I could see it coming up. The abatement period needs to be shortened because it's a safety issue and we don't want the workplace to be unsafe for a longer period of time. But again, trying to think of a fact situation where it would be, justified. But again, I don't think it's going to be granted for the convenience of somebody. It's more of a, there would be a serious, there would be a serious consequence if it wasn't granted. You'd have to make a case for that. So.
Well, I this were probably we're doing a tighter rein if we were having an official meeting over questioning policy rather than the rules that administer policy. Are there any further questions for the witnesses?
I would just like to make sure that Dirk Anderson gets a chance to, Dirk Anderson gets a chance to voice any concerns he has over the rules or comments.
Thank you. On behalf of the department, I just want the committee to know that this was a very transparent process. We asked some questions, we had some issues. Carolyn and Lee addressed all of those and they are in the materials that you have. So we're supportive of the rule and we appreciate the time that has gone into it by the review board.
So,
Quick question.
Break.
Just a procedural question. So since we're having a 2 week unrequested delay that none of us looked for, are you planning on resubmitting the rule with the corrections noted in council's memo and the cross-reference sorted out? Like basically a clean edited version for our next meeting?
What would you like us to do?
Well, I would defer.
What would you like us to do?
Well, you prepared a memo, if it says to amend in the, A, B, and C places.
Right.
One of the members of the committee can move that happen. I don't type out the whole shebang. So.
I know you mentioned that we might have to request an extension. I think we'll have to look at the dates. Carolyn, do you remember?
So your 45-day review period, LCAR's 45-day review period is 7/30/21. And our next meeting is 7/29, so I think you're okay. The 8-month adoption deadline is August 3rd.
Yes.
So you're gonna need to, if you can't file the adoption deadline by August 3rd, you can request on the 29th adoption deadline.
I think with the basic changes that have been requested at this point, we won't need to ask for an extension, but if there's something more significant, we may have to.
So I think that Charlene has said we've met the deadline by 24 hours. Okay. Any further questions? Chair Lee Kaiser,
You got it right.
Are you, is this your last time you'll be appearing?
Probably. I was sort of wanting to get this project done and then I will be retiring, yes.
So, may I, on behalf of the committee and in one of your last official acts, thank you for your tireless work over
Thank you.
on what is often a dry but important subject and
Well,
requires
thank you.
attention to detail. So,
Yeah.
thank you.
Well, very well.
Are we,
Yeah.
Thank you.
Thank you very much.
Thank you.
Chair, I know you're about to go to another thing. I'm going to talk to Dirk outside if I could for just 2 seconds.
Sure, we're not being stampeded this morning by any.
You're
Any chance?
suppressed. I don't understand.
We'll take a short recess till Senator Benning comes back and we have
Thank you very much.
oh, thank you.
Thank
Sort of an end of a multi-year process.
End of an era.
And we apologize for having so few people here
That's
to.
okay. I mean, it's summer.
Yes.
I think our hangup was that people, we've done so many meetings in which you could legally vote by remotely. That some people didn't realize that
Yeah.
as of the 15th, you now have to be, because it's the
Have
old.
at least a quorum.
Wow.
Be present.
Yeah, interesting. Yeah,
Yeah.
that's interesting.
Yeah.
I wonder why, because if you're voting, if it was okay in the past, why not now? But I guess they're trying to,
It's not okay in the past to vote on a meeting that you did not attend.
oh, no, yeah,
It was
right.
special rules during COVID that
You allowed
the tradition broken. Allowed
to allow, right. Okay, I see. Yeah, all right. But
an
then
emergency rule. We have to
people
have.
got used to it, so they just,
Yeah,
I can understand.
It's very convenient.
Yeah, it's very convenient. Yeah, exactly.
it's convenient and has different dynamics as part of a democracy and
Yeah.
open.
Yeah, well, it's, anyway, well, thank you all very much. Appreciate your time.
I think you should.
Are we still
Done by
live?
11.
Excuse me?
We're still live?
No,
Sorry about that.
we're on a recess here. We're about to go back.
There's enough room for both of us to
We are live?
get settled.
Okay. Well, no harm done.
Yeah.
So apparently we have been live. Which brings us to the next rule, 21E08, Department of Financial Regulation, access to healthcare services related to COVID.
Thank you.
And Sebastian
Arduengo.
Arduengo. Arduengo.
It is pronounced exactly how it's spelled. So yes, good morning, Senator McDonald and Senator Bray and Senator Benning. We are here this morning to discuss the department's proposed emergency rule titled Access to Healthcare Services Related to COVID-19. My name is Sebastian Arduengo, and I'm appearing this morning on behalf of the Department of Financial Regulation. This emergency rule basically continues our previous emergency rule with respect to COVID-19 diagnosis, treatment, and prevention. And if the committee will recall, the department adopted an emergency rule in October related to healthcare services during the pandemic that had 3 major parts. One of them was this COVID-19 diagnosis, treatment, and prevention. One of them was access to audio-only services, which has been addressed in a separate order under Act 6 of 2021. And one of them was the waiver of certain prescription drug deductibles. This only addresses COVID-19 diagnosis, treatment, and prevention, and not the waiver of prescription drug deductibles, even though the legislature gave us that authority under Act 6, just because of the continuation of an improved economic outlook in Vermont. Unemployment is historically low, and the department has taken the position that if prescription drug deductibles are going to be waived on an indefinite or continuing basis. That's something that the committees of jurisdiction in the House and Senate should take up.
So you have chosen not to
Yes, we have,
do that, and
that's
it would
correct.
take a law to get you to do that.
Yes, even though we have the authority to do that, we believe it's best left to the legislature at this point. So the reason that we have opted to continue the emergency rule for COVID-19 is that even though the federal protections introduced by the CARES Act and then continued by the Consolidated Appropriations Act require health insurers to cover COVID-19 testing and COVID-19 vaccination without member cost sharing. Those federal protections do not extend to COVID-19 treatment. Under federal law, members of health insurance plans are by and large still responsible for their deductibles and co-payments if they are hospitalized or treated for COVID-19. So because there's still not an FDA approved or authorized vaccine for children under 12, and also there have been a number of breakthrough cases in Vermont in which an individual who's been vaccinated becomes ill with COVID-19. We have opted to keep the emergency rule in place that requires health insurers in Vermont to cover COVID-19 treatment without member cost sharing, whether it's on an inpatient or outpatient basis.
And in this case, you've made your decision because you believe that the rules call for this. It's not at your discretion, or you're saying this one is also at your discretion?
Yes, this one is at our discretion. Act 6 continued the language that was in Act 140 of 2020 that said that the department shall consider adopting, and after consideration, this is what the commissioner has opted to do.
Thank you. Senator Bray.
So is the difference between these two choices that for sort of the extraordinary costs that could come up related to a COVID infection, whatever, illness, whatever we call it, as opposed to just general medications?
That's right.
So you're hewing to the COVID exposure that's still different, but on the economic front, you're saying with an economic recovery underway, that for medications more generally, the
That's right.
normal rules of the road apply again. Okay, thank you.
So I also wanted to advise the committee that after communicating with Lex Council, we need to make two minor corrections post-filing. One is a comma in section 1C of the rule that is should be in your packet, but because there was a copying error, I just wanted to specifically note it in my testimony. It's a comma after the word for in section 1C. And then in section 6, the authority that lets us continue this rule until March 31st, 2022 is contained in section 3 of Act 6 and not section 8.
Questions? This would be, thank you. We have your memo and a motion. I'm sure would have been made by one of the members of the committee where we holding a session in which we were making motions.
Yep.
And I want to thank Senator Bray for his last question, which was getting at the same thing I was, but was phrased more artfully. And,
Well, thank you. And if you have any questions, or if any of the members of the committee who aren't here have any questions, I can be reached by email or phone, and that information is in the filing.
The suspense lingers for 2 more weeks now.
Yes.
and Charlene, what's the timeline on this one?
This one,
Review period ends 8:15.
Okay, yeah, it's on the
yeah, they got
8:15, so we're good.
plenty of time.
We're good.
All right. Well, thank you very much.
Thank you. Thank you. I don't know what kind of a record there is of this meeting because it's not an official meeting, but if we had one, thank you, Representative Swirl, coming across from your other meeting in an attempt to, we did, Senator Lyons, it's not meeting in person, so this is a unofficial, we're not taking action, but we've had witnesses that we believe have tried to answer questions on the committee's behalf. And I don't know how to adjourn a meeting that is not official.
You don't need it.
No.
Well, we can, well, Charlene to take us offline.
So just for those of us that are here,
Take off live.
pardon?
You want me to take you off live?
One more item that at the last meeting, official meeting, we had to ask Jen Carby to write a letter to committees of jurisdiction on the rules from a couple weeks ago. And we'll bring that up to perhaps amend the minutes of our last meeting to include that. But otherwise, I think we're done for today. It's a nice day out there. So Charlene's going to take us offline. And for those of you that are watching because there's nothing better to watch, we apologize for going off the air. Thank you.
We're better than you.